Federal Justice Minister David Lametti has committed to reforming bail. The provinces have been pushing for stricter rules, including a reverse onus for certain firearm and violent weapons offenses that would require the person seeking bail to demonstrate why they should not remain behind bars. Danardo Jones is a law professor at the University of Windsor, and last week he appeared as a witness in front of a parliamentary committee looking into this issue. And there was a tense moment when Conservative MP Larry Brock questioned the source of Jones' statements on the bail system.
That the bail system is a proxy for punishment, that judges need to be aware of the racial realities on the ground. Where are you getting this data from?
The Supreme Court of Canada has said it over and over and over again.
Right.
And also
and we have Antic, and we have Zora, and we have from the Court of Appeal in Ontario, Morris, which was an anti-black strategy. You're aware of that?
I've written on it.
Professor Danardo Jones is with me now. Professor, thank you so much for taking the time.
Thank you for having me.
I wonder, sir, what was going through your head at committee last week when that interaction was going on?
Well, it was uncomfortable to say the least, but I ensured that I didn't fall into a back and forth that detracted from the central topic, which was bail reform and perhaps the constitutionality of any approach that the government plans to take on that front.
When you saw that line of questioning, the challenging of the data and the facts that you had raised, are you concerned about how this issue could be dealt with at the federal level, given the political climate?
And it's interesting, right? Because the facts are almost insurmountable. They're there. They've been there for the last 30 years. It's something that the Supreme Court of Canada has recognized. It is something that is beyond questioning. It's a notorious fact, and it's not left up, I think, for debate between reasonable people. What we need to figure out is how do we account for these facts in coming up with public policy that takes into consideration constitutional rights and also public safety.
So that is the challenge right now, as the Justice Minister has promised a recalibration of bail laws based on the push from the provincial level to change some of the measures in Bill C-75, which to deal with some of the overrepresentation in the justice system. That's now been criticized as creating a catch and release bail system. What issues do you see as they try to recalibrate how bail is granted to deal with these competing issues here?
The issue is not with the law itself. The issue is with how the law is applied. Bill C-75 brought in some pretty progressive measures, but it's about how the law is applied and also the social infrastructure on the ground to ensure that people who are released on bail are not set up to fail and that they're able to thrive pending their trial. So that's what the issue is. The issue is about the social infrastructure to ensure that people who are on bail are able to thrive pending their trial. That is the issue. The law itself, at least the amendments that section that C-75 brought in, were actually quite progressive. Is there work to be done? Of course. But for us to engage in some form of retrenchment, to go back to a time when bail was more punitive, I think is constitutionally suspect.
So what change then do you think is necessary here, or what change do you think is advisable here? Because it seems change is coming. What would you recommend?
What I would recommend is that there be more resources poured into bail support programs and also poured into communities to ensure that people who are accused of criminal offense or accused of a criminal offense is given the best opportunity possible to thrive and not pose a risk pending their trial. That is where the issue lies.
Right. So while at committee, you quoted the court saying the system is profoundly anti-black. How do you think this push for bail reform will impact marginalized people in the system if they go ahead?
Well, here's the thing. We know that, an unenviable amount of criminally accused people hail from marginalized and racialized communities. So it's not unreasonable to suggest that if there's increased punitiveness in our bail system, that it's going to fall disproportionately on these very marginalized and racialized people. So we have to move ahead with any approach to reform with that in mind, how it's going to impact folks that are disproportionately caught up in the criminal justice system.
Right. We don't yet know the specifics because it's a criminal code amendment that needs to be tabled in Parliament. But there has been a unanimous push for a reverse onus on firearms-related offenses, a conversation about knives and bear spray and other things that can be used in the commission of a crime. How would you suggest David Lametti, the Justice Minister, calibrates that reverse onus to avoid unintended consequences?
Well, we have to think about how justice of the peace take into consideration risk. What type of indicia of risk calls for detention? So in a reverse onus situation, we're thinking about essentially the accused person having the best evidence to prove why they should be released pending their trial. And oftentimes that requires them to put together a bail plan that mitigates whatever risk a justice of the peace or a judge deems that they pose. Again, going back to my comment about social infrastructure, a lot of times this requires sureties. It requires people to have addresses, jobs, and so on. And these things, unfortunately, given our social climate, it's not something that is typically accessible to a lot of people who come before the criminal justice system. That's something that the Justice Minister has to think about when we're thinking about whether or not we're going to make it more difficult for people to have access to their Section 11E charter right.
No, you make an excellent point. I mean, the social determinants in this are profound in affecting outcomes. And we know that Justice Lametti has also launched a review, a Black Justice Review, to try to deal with some of the challenges in the justice system. When we see this eventually, hopefully, I think the minister said we'll see it before Parliament rises for the summer. I mean, what's the number one thing you hope to see in this that would give you some comfort that this is being done in a correct way?
That race is on the table when these measures are being discussed and when they eventually become codified. We have to ensure that that social context is there in the forefront. As long as that's there and it's seriously considered, it's seriously weighed in deliberation, that is what I think all of us as Canadians can expect of our public policymakers, is to make sure that all the evidence is on the table when a decision is being made.
Okay, Professor Danardo Jones, thanks for joining me tonight. And when we see these changes, I hope you'll come back and give us your input on where this is going.
Thank you for having me.
All right, thank you very much, sir.